Hello, I'm Shauna Sullivan, Senior Director of People and Operations at the Chamber, and I'm happy to serve as moderator for today's session. COVID-19 has undoubtedly impacted each of our businesses and our workforce. We hope that today we can provide clarity surrounding new legislation as well as existing employment law. We know you are all working to protect your employees and your business during this time. As Jill just said, last week the Chamber introduced virtual business briefings to help keep our members informed of the rapidly changing environment. These briefings feature experts in various fields sharing information so that you can make informed decisions within your organizations. Today's topic is a meaty one. We know we won't cover everything you need and want to know today. So following today's session, tomorrow morning at 9:30, the Chamber is hosting a roundtable discussion where every participant will have the opportunity to ask questions, share information, learn how other regional businesses are dealing with the emerging HR issues. To attend that virtual briefing, I encourage you to visit the Chamber website and register today. Before we launch into today's call, I briefly want to mention two other resources that will be helpful to you. The Chamber launched a business response helpline yesterday that you may call during regular business hours. We will pull from our research database, info and resources, and provide those to you quickly. Also, if you haven't signed up for the Chamber's newsletters, we're sending regular COVID updates. If you aren't sure if you're registered for those, you can call our Customer Focus Center and they'll walk you through the process, or you can go to our website. All phone numbers that I've mentioned for the Customer Focus Center, as well as the helpline, are on the homepage of our website currently. And we're updating our website continually and are currently building more substantial content for all of you. Today, you're going to hear from Matt Rich. Matt is a shareholder at Katz, Teller, Brandt, and Hild, where he practices in the areas of management side employment law and civil litigation. Matt routinely counsels employers on a wide array of employment-related issues, from employment agreements and hiring practices to day-to-day discipline and employee management to employee termination and severance. He also frequently prepares policies and employee handbooks and educates employers in compliance areas, including worker leave entitlements, wage and hour issues, and the avoidance of harassment and discrimination in the workplace. Matt has been an Ohio super lawyer since 2017 and is on the list of best lawyers in America since 2013. He is also a member of the inaugural class of the Chamber's Leadership Action Program and the inaugural class of the Chamber's Building Cultural Competence Program. Matt is a graduate of Bellarmine University and earned his JD from Cornell Law School in 2004. Before I turn it over to Matt, I want to inform you that you've joined this briefing in listen-only mode. Your microphones are muted. You may submit questions for Matt's real time by typing your question through Zoom's Q&A window. I want you to take a second right now, find that Q&A window and pop that out because we really encourage your questions today. We'll cover as many as we can within the 1 hour time frame we have, but we know we won't be able to get through them all, and so we hope you join us tomorrow morning. This full webinar will be available on Facebook through the Chamber's page so that you can view it later or share it. So without further ado, I'm going to kick it off with our first question for Matt. So Matt, on Sunday, Governor DeWine issued a shelter-in-place order that took effect last night, right before midnight, and this order resulted in the closure of all non-essential businesses. For each of you joining, that means that if you were deemed a non-essential business, you must either close or shift your workforce to a work-from-home arrangement. So Matt, first of all, is it true that all non-essential businesses must close or work remotely? And then what if I'm a non-essential business, but let's say my payroll processing system, it's not cloud-based, or I can't access it through a VPN, or if a large portion of my staff relies on large equipment that's in our warehouse, are there any exceptions to this?
So Those are really great and timely questions. I spent the majority of the day on Sunday after everyone watched Governor DeWine's press conference and became in a panic-stricken state, and then all day yesterday answering questions about how do you draw the line between essential and non-essential. We're really fortunate that Governor DeWine issued a 23-page order that really spells this out with some degree of detail. But to your question, you are correct. All non-essential business is required to close or work remotely, with the exception that minimum basic operations can continue. So you gave the example of payroll processing. Payroll processing is specifically enumerated as one of the minimum basic operations of a non-essential business. So payroll processing can continue. And if the employee needs to go into the workplace to do that, the shelter-in-place order does not forbid that. Your question about the equipment, the large piece of equipment, a little more nuanced. It really depends on why the worker is visiting the workplace to see the equipment. If it's to maintain it, if it's to preserve it, if it's to secure it in some way, kind of protect the business's asset, then that's covered. That's allowed. That has not been forbidden. If it's to operate it in some way, that can't happen. That is expressly forbidden. The list in Governor DeWine's order is longer for essential businesses than it is for non-essential businesses. If I had to say what all of the non-essential businesses really have in common, it's that they all kind of add embellishment or color or diversion or fun to life, but we could probably, if we had to, do without each and every one of them in a crisis. So things like museums, aquariums, bowling alleys, theaters, basically cultural, social group gatherings such as country clubs, all of those types of things are non-essential. Everything else, it's going to be determined by the remainder of the order, and it's a very broad order. So 4 main categories of essential businesses, and those are healthcare and public health, human services, essential infrastructure, and essential governmental functions. But there are a host of other businesses that are ancillary to or that provide services or are in the supply chain for those businesses that those businesses depend on to be able to continue their essential functions. And those supply chain or supportive businesses are also specifically exempted from the governor's order. If you haven't read it, I highly recommend doing it. If you're confused about it, consult counsel, but it is a really great resource.
So Matt, we had 2 questions come in relevant to this discussion right now. Someone asked, should we provide our employees a letter to carry with them to show that they're operating as an essential business?
So I've had that question come up. The order does not require that, but I can't see that it would hurt. The police, I think, in at least Hamilton County, have announced that the way that they're going to regulate the governor's shelter-in-place order is really going to be focused on preventing large groups from gathering or congregating. I know we've all seen, the sight of spring break revelers in Florida or people in California crowding the beaches despite the orders. The police, I don't think, are going to be taking a proactive stop cars, demand paperwork. I don't think it's going to be that situation, but that can't hurt. So if you've made the determination that you are an essential business and you want to provide your employee with that kind of cover in the event that they did get stopped, I think there's no harm in that.
Great. And another question, Matt, that came in. So for folks that aren't really sure how to interpret some of that language about even determining if they would be considered an essential business. So you're first saying everyone should make sure that they're reading that order. It's 23 pages. I think you've said 23 or 24. So it is totally doable, and it's not filled with heavy legalese. So it's fairly understandable. But I think what you and I've discussed is it's not overly detailed, so that it is, there are some questions that are coming from folks on a few things. So for folks that don't have legal counsel to consult to help them make that decision or help them determine what are essential functions within a non-essential business, are you aware of a number folks can call to help them with that? Is the governor's office promoting anything?
So I've been refreshing a variety of websites over the last week and a half. That's not one thing that I'm particularly familiar with, a helpline number. If someone is familiar with it and it comes up in the discussion group, we should mention it. But I haven't seen any resource specific to that. I've just been kind of digging into the text and answering, but I do agree with you. If you don't have legal counsel and there are gray areas that you'd want guidance on, that resource would be helpful. I'm just not, off the top of my head, I'm not sure what it is.
Okay, great. So I would imagine that there are many businesses that have not set up a work from home model before, or at least they haven't done so across their organizations widespread. I know on the chamber website, we're trying to push out resources that we are finding helpful, that folks are telling us they find helpful, to help them think through business continuity and specifically remote work. And we're continuing to curate and build that library. But Matt, for businesses and where things are moving very quickly, I'm sure there are a few compliance issues that we can flag for them as they shift to this remote working model. And so, for instance, things surrounding hourly workers and requirements to still continue to track their time, thinking about overtime when it's hard to police what folks are doing remotely. What are some flags that you would point out for folks?
I think that's a really big one. So the Fair Labor Standards Act still applies. Hourly workers are required to have and the employer is required to have a log of the hours that an individual works, not just to make sure that you're processing payroll appropriately and paying each employee for every hour that they work, but also as a matter of record keeping compliance with in the Department of Labor regulations. And so what I would say is, whether that be a self-report system or some sort of timekeeping or an electronic timekeeping system, there do need to be hours recorded, and pay still needs to be based on hours worked. And obviously that does create, and that's sort of the problem with telework even before we had this crisis, is that it's a little bit harder to monitor, and you're sort of trusting your employee. And then of course monitoring the work that's being performed, and if it seems like there's a productivity issue or things are taking longer than they should, that's something that you can obviously, the employer retains the ability, has the toolbox to discipline that, or to issue some sort of corrective action to fix that particular problem. But it's a little bit at you're having to trust your employees' inputs in that regard, because you can't be physically in the house with them.
And I think that's probably a question, Matt, that many employers may be asking themselves, right? There's obviously flexibility working from home, right? I have a child in the home with me right now, so everyone can expect a cameo appearance, I'm sure, at some point. But at what point, if it's interfering with someone's ability to complete the essential function of their job, you're saying that employers can take the same action that they would normally? And so do they just use their judgment on how much flexibility versus when action may need to be taken?
Yeah, presumably the telework assignment isn't just busy work. It's actually things that need to get completed, things that are important to the business, or the business might have done another one of the many options that people are confronting with respect to their workforce right now in terms of layoffs or temporary furloughs or other arrangements, reductions in hours. So I would assume that the business has the ability to still monitor and determine whether it's satisfied with the output. And if it isn't satisfied with the output, it's always, employers suffer or permit their employees to work, and it's at the direction and at the terms of the company. So you as the company have the ability to discipline that however you wish, consistent with your policy, past practice. Obviously can't be selective in how you discipline. Still need to make sure that you're treating people similarly and not creating potential disparate treatment issues. But yeah, there's still resources that a company has at its disposal to address underperformance.
So it's really finding that balance, right? How do you allow for flexibility for your workforce and understanding that their 8 to 5 may not look how it would if they were in the office, but also recognizing that it's important to really stay connected to your folks and your team and understand what people are doing. What about employees that don't have work that can be performed remotely?
So if a company just doesn't have work for a particular employee, at that point, the employee, there are a number of options, depending on what the company's cash flow is, what the business needs are long-term potentially. So there are, layoffs. It can be a permanent separation or maybe contemplated to rehire, but it's effectively a separation where that individual would be eligible for unemployment, which we can talk in a little bit about some of the updates to the unemployment rules. If the employer is more than 20 employees, would be eligible for COBRA, or if it's under 20 employees in Ohio or Kentucky, would be eligible for what's called state mini COBRA. So statutes that the states have that mirror COBRA for smaller employers. But the employer's pay obligation at that point would cease if that were the decision to be made. Some employers are kind of going with a middle ground approach and saying, we're going to put you out on a temporary furlough where we maintain your benefits, provided the insurance company is on board with someone who isn't working the requisite number of hours to obtain benefits or to qualify for benefits. They'll continue those benefits and it will be temporary. And when we're able to come back, you'll come back. So that keeps a little bit more of those strings attached to that particular worker, that you don't have maybe as much of the, they might find another job in the interim, or I'm a little concerned about my ability to rehire. But those are the options. Of course, the employee, if he or she has paid time off, and there's no work to be done, if the employer's policy allows, the employee could use paid time off. The employee may qualify for some of the federal leave entitlements that we'll talk about in a little bit. But if there's no work to be performed, there's no responsibility on the part of the employer to create work to sustain employment.
Great. I know that's helpful to folks because I'm seeing the questions come in, and I wanted to just echo what you said. We are going to cover the expanded FMLA and paid sick leave. We're going to get through a couple of topics for those businesses that are continuing in-person operations, and then we're going to dig into those two pieces.
Sure.
And so for those essential businesses that are continuing operations as usual, they're still facing the risk of spreading COVID-19 amongst their workforce. So what if they have an employee that is showing symptoms? Can they take action?
So the answer to this question is absolutely yes. And it was absolutely yes before the governor's order specifically mandated that they must take action. And so the reason for that is communicable diseases in the workplace are an exception from the usual practice that we all in HR and counselors in HR abide by, which is you don't ask an employee or you don't lead with your chin when an employee has an illness or a sickness, because if you don't know that they've got a condition, you cannot possibly be alleged to have discriminated against them on the basis of that condition. So HR people are trained not to inquire there and to make the employee raise that issue up to the HR professional and then deal with it, whether under the FMLA or under the Americans with Disabilities Act and an accommodation. In this instance, because of the threat of communicable disease, the employer absolutely can send the employee home. It isn't disability discrimination, because if the cough or symptoms were not COVID-19, were not a communicable disease, then that doesn't rise to the level of a disability. So someone couldn't make a claim on that basis. If it is a communicable disease, there is what's called a direct threat exception to the Americans with Disabilities Act that allows you to preserve the good of the whole to the detriment of the single employee. So absolutely, that employee who's exhibiting symptoms should be sent home. The governor's order requires it, at least in Ohio. So that's a pretty clear yes to that question.
Okay, great. So I'm going to play a really terrible devil's advocate here. What if there's an organization that knows someone is showing symptoms, but that person is in such a critical role that they don't want to send them home? And I think you just answered this, but I want to make sure we're clear. Are businesses required to protect their other employees in the current environment? And I think you just ended on this.
Yeah, yes. So Governor DeWine's order puts a really fine point on this, and I'll read it specifically. It says, separate employees who appear to have acute respiratory illness symptoms from other employees and send them home immediately. They are not to return until they have no fever for 72 hours and have exhibited no symptoms for that same period. So that's a really clear-cut communicable disease spread prevention measure that's actually required by the governor's order, at least for Ohio businesses.
Okay. And then, so I send someone home. What benefits may they exercise generally, and in what order in the event that they're required to leave the office?
So if I'm sending someone home and they've got paid time off, they can exercise the paid time off benefit compliant with the policy. They may qualify depending on whether they in fact do have COVID-19 or whether they're exhibiting symptoms and seeking a diagnosis that's consistent with COVID-19. They may qualify for the paid sick leave, the federal paid sick leave that we'll talk about in greater detail, or they can be out on unpaid leave until their symptoms abate. What I would caution is not taking steps to be punitive with these employees or to terminate these employees. They've been held out of the workplace, at least under this hypothetical, by the employer. And the governor's order also stresses that businesses should be flexible with individuals who are in that particular situation. It's not a situation that they obviously want to be in, but they find themselves in it anyway. And the governor's order stresses that businesses should try to be flexible.
So the first thing that's triggered, you're saying, is just your company's normal leave policies. So whether it's sick leave, PTO, whatever that may be, that's going to get triggered. And then you're going to talk shortly about the very specific reasons that will trigger the paid sick leave that was put out by the current administration. So that federal benefit that's new. We'll talk about that.
I should stress that the paid, the PTO leave that the employee can exercise, the employee often gets to choose whether they wish to take paid or unpaid leave in that circumstance. Obviously, many employees in that situation want the money, want to take the paid leave, but unless your policy requires them to use it, it's usually at the direction of the employee whether that time away will be paid or unpaid. They're using a benefit that you've provided them as the employer. Okay.
And then for organizations that are changing the work assignments of their staff right now, either as a result of changing work models due to work from home, or if changes due to headcount from downsizing, can you change an employee's responsibility at any time, right? That's the little sentence that we all add at the end of job descriptions and other duties as assigned. But is there anything that should be considered when employers are needing to make significant changes to job roles?
I think the only thing that really should be considered, and it's a little bit hard to see how this is going to be enforced, or that the Department of Labor is really going to be draconian when it investigates this, is if you have an exempt employee whose substantial duties or the majority of their duties now consist of what are non-exempt duties, what are more administrative, ministerial, kind of lower level duties, and that makes up the bulk of that individual's work, and this stretches on for long enough, there's the potential that the exempt employee, the salaried employee, might not qualify for the exemption anymore. I think given the current crisis that we're in, I'd be surprised if that were the position taken. That's particularly uncharitable, but that's a possibility. Otherwise, absolutely, the employer gets to direct and control what the employee does and doesn't do for the compensation that the employer provides. And so maybe with one caveat, to the extent that there are employment agreements that are maybe with higher ranking C-suite employees that really cabin the employer's discretion to make those changes, that might need to be something that's mutual. Otherwise, I think there's a lot of freedom here and likely little risk.
Okay. We've had a question come in from Jessica, and I'd love to get your thoughts on this. I think I know the answer, but you're the expert. So Jessica wants to know, would it be allowable to request any employee or employee family member that contracts COVID-19 to alert HR confidentially so that they can then work with the employee on understanding the benefits they may be qualified for? So can organizations put that in policy right now? And I think you addressed this somewhat earlier, but just want to confirm that.
So that's actually a relaxation of the traditional HIPAA rules. Yes, that communication. I mean, we had the governor even suggesting that the employer should take employees' temperatures before they walk into the workplace, which obviously is nothing that would ever fly if we were operating business as usual under employee privacy and HIPAA concerns. But for this time period, while we're dealing with this epidemic, this pandemic, absolutely that can be required, and the employee would need to make that disclosure.
Okay, and we've had another question come in, and it's one that you and I had discussed. What if employees are scared and aren't comfortable being in the workplace, but they're not symptomatic?
So at least in Ohio, that's going to come down to whether the employee is in an essential business that's been permitted to continue, or is in a non-essential business that's been closed and can only do minimum basic operations. If you've got an essential business that is permitted to continue, and you have a worker who doesn't have maybe a good reason to suspect an exposure, but just has a generalized fear or anxiety, so long as that fear or anxiety isn't creating a condition for which they're receiving treatment and they'd be eligible for FMLA if you're a large enough employer, unpaid FMLA that is, that employee can be required to come into work by the employer and can be disciplined if he or she fails to report. Now, obviously, the governor wants flexibility here, but if the employee unilaterally got to make that decision, if they could say, you know what, I am worried about stepping foot outside my house and I won't show up to run this essential function at a company that's been identified as an essential business, that presents a real problem for the employer. And the way that they can deal with that is through the typical discipline measures that they might otherwise take. Now, obviously, it's different if the employee has symptoms or has a family member with symptoms. There are a whole host of other fact patterns that might lead you to conclude differently. But if it's just, I'm afraid, and it's not based on anything that from which a direct fear could be taken, I would say that that's business as usual, and the attendance policy would apply.
And then we had a follow-up question. So thank you, Matt, for that. Follow-up question from Len on something you mentioned earlier. How do you differentiate between the 72-hour rule that you mentioned and then the 2-week recommended quarantine?
I would say the differentiation is that the 72-hour rule is what's been required. The 2-week quarantine is a suggestion. It's a recommendation. And so you know, the law sets a floor, not a ceiling. And so at a minimum, to comply, at least in Ohio, with the governor's order, the 72-hour rule is what you must meet. You can obviously choose, if you so choose, to have a 2-week policy in place. They would still need to satisfy, say the symptoms lasted, as we're hearing, some people present with symptoms that last quite some time. They would still need to satisfy that 72 hours since exhibiting a fever and 72 hours since exhibiting symptoms in order to return to work. So I would say at a minimum, it's they must comply with the 72-hour rule. The other 2-week is a suggestion that an employer could comply with.
Okay, great. We've had a really interesting question just come in while you were answering that one. So what do you recommend for Northern Kentucky employers who employ many Ohio residents who are being ordered to stay at home? So the businesses is continuing to operate. Are their employees able to come into work?
So that's a great question, because it's the difference between the Kentucky order, which is directed at non-essential retail operations, places that would have customers congregating and really addressed in that way, versus the broader Ohio order that just applies to non-essential businesses, not just retail. And so I guess what I would say is the business in Kentucky is governed by the governor of the state of Kentucky, at least with respect to these rules. I believe that the employee, if he or she were to say, hey, listen, under my interpretation of the Ohio governor's rules, I can't report to work, that might be a call for some leniency on the part of that Kentucky employer. But that cross-jurisdictional issue is not one that the two orders neatly resolve. So there's not a direct answer to that question, at least to be found in the orders. And the idea that a governor would issue such an order is not business as usual. I mean, these are unprecedented things that are happening. So I don't rightly know how that would go. I think the Kentucky business is permitted to only follow the Kentucky order. But that's a very good question. This and many kind of thorny issues under these orders, and also under the federal legislation that was passed, there needs to be, and there will be, at least in terms of the federal legislation, rulemaking, regulatory rulemaking that's going to fill in a lot of the gaps and answer some of these thorny questions. So I kind of winced when you said you had an interesting question, because over the last week, that's meant one that I can't really answer all that easily. So, but that is one. I'm not quite certain what the right answer to that is.
Okay. So another question that came in, with so many employees now working remotely, what if those employees do not have the necessary tools available in their homes to complete their jobs? And a very basic one would be, what if they don't have internet access, or a strong enough internet access that would allow them to fulfill their duties?
I think if the employer is not in a position to provide that to the employee, whether it's a Wi-Fi router or their work computer, if their home is not outfitted in a way that allows them to telework, then telework isn't available. This isn't a situation where it's a disability accommodation and the employer needs to remove that impediment to meet the employee to make an accommodation. This is a flexibility measure, and if the employee can't telework and the employer doesn't have the wherewithal or the means, or isn't willing to make that, to facilitate that in some way, I would say that telework's not available.
Sorry, muted myself. We're continuing to get great questions coming in. We're going to try to cover those. We're going to shift into the sections that a lot of your questions are about, the expanded FMLA, furloughs, paid leave. And so hopefully it answers some of your questions that are already in queue here. And so, we know many of you are facing really difficult decisions right now. You're experiencing hits to your revenue that may be significant. You're forced to change operations and revisit your budgets. We know that you're looking for solutions other than reducing headcount, but also know that sometimes it's unavoidable. given financial realities and the uncertainty of the future. So, Matt, if we start the need to reduce headcount, when an organization is forced to make this decision, how is this scenario any different than any other employee termination decision, if it is? And then what are the main things that companies should make sure to do or not do when engaging in decision making and conversations?
So I would say any termination, whether it's on a larger scale like a reduction in force or on an individual scale, should be based on the needs of the business. And on an individual scale, if it's performance related, it's because the needs of the business aren't being met. Its expectations aren't being met. The continuity of operations, especially during this time, is another factor that a business ought to be looking at. And so what I would say is, it is a decision that should be made with an eye toward what does the business actually need. There are certain things that can't be considered when making these decisions that I think employers are very familiar with. Can't discriminate against someone or can't include someone on a list on the basis of their membership in a protected category or class, age, race, sex, color, creed, religion, disability, national origin, veteran status, or if they've exercised protected activity, they've maybe made a workers' compensation claim or filed a complaint with HR, or they've exercised family medical leave. Their inclusion in the list of workers who are being let go has to be blind with respect to those factors. But you can consider things like tenure or duration of employment, seniority, flexibility. If you've got someone who's kind of a five-tool player who can fill a lot of different roles, that person might be preferred over someone who can really only do one thing day in and day out. Employee skill sets, their performance history, their discipline history, and then in light of whatever the specific business needs are, that's how you determine who might be a part of that reduction in forced group. When I do these calls with an employer, I'm always kind of toggling in and out between micro, this person we think should be on the list, and then you have to look at the macro list that's being created and see whether there might be a basis to say that some discriminatory animus is guiding the selection. So you wouldn't want to have a situation where you create your list and your list just so happens to include everyone over 60. Those are the main concerns with who gets included on the list. And then there are a whole host of issues over whether you're doing a true reduction in force, whether you're ending the employment, or whether you're doing something a little bit more temporary.
Okay. We received some questions early on, Matt, about asking for distinction between a reduction in a headcount that's permanent versus a furlough. Can you sort of talk through that a little bit to bring some clarity there?
Sure, and in terms of the major change in how this is being treated in unemployment, both employees who have had their headcount, who have been reduced, who have been terminated, or employees who are out on furlough, both will be eligible for unemployment immediately, which is different from how it normally is. The main difference is under a furlough, under kind of a temporary leave, the ties that bind an employer to an employee, the benefits that are offered or available, those remain intact. So if you had employer-sponsored health insurance, that policy would remain intact unless, and this is an open question as to whether insurance companies are going to lighten up in how they traditionally look at this, unless the employee falls below the required number of hours to get benefits for a long enough period, in which case there may be a trigger for COBRA, or if the business is smaller, state mini COBRA. So the real differentiation is A, the permanence of the decision, and B, the maintenance of benefits.
That's helpful. So Matt, in addition to those actions, we're hearing that employers are considering things like hours reduction. Any issues with that? So you mentioned earlier FLSA. Any issue if I'm reducing hours? Let's say I generally have everyone that works a 40-hour work week and I want to move everyone to 30 at this point. Can I shift everyone? Can it be case by case? What are some things that organizations should be aware of there?
It can be case by case as long as the basis is not some reason that is discriminatory. So it can be case by case based on business need or the legitimate business requirement, but it can't be case by case if there's a discriminatory motive in the decision. And I would say absolutely, there's less work for many businesses. There's less work to be done and less need to have full-time people doing the amount of work that remains. And so changing an employee's hours maybe as a way to stave off the potential that you might have to do one of the more permanent layoffs or a temporary furlough. I absolutely think that that's something that an employer ought to be considering. Likewise, reductions in compensation. Can't take an hourly employee below minimum wage, can't take a salaried employee below the salary level of $684 a week, which is around $35,000 a year. Can't take the employee below that level if you want to maintain exempt status, meaning that they're not eligible for overtime. But on a going forward basis, and you can't do this retroactively, it has to be for time that they haven't yet worked, not time that they've already put in, because they put in that time at whatever wage rate you agreed to at that time. But for future work, you can absolutely make those changes, kind of belt tightening measures in order to prevent larger crises for your workforce.
And related to that, a question had been put in, if employees that have offered to take time off without pay sort of help cut expenses for the business and for the greater good, that's wonderful. If you have folks that are able to do that and are volunteering to do that. But is it, at what point, and I'm sure it's going to depend on their compensation, but the question is, at what point is it better for them to be laid off and take unemployment as opposed to taking an extended unpaid leave?
At the point at which the business can't maintain the benefits, it's really kind of a cash flow question. The employer contribution to insurance, whether the employer is still carrying that cost or whether that cost can be shifted to the employee during the unpaid leave. If it's not an FMLA leave, under FMLA, as we'll talk about, you have to maintain insurance and pay the employer portion of the insurance premium. But I really think it's the distinction is going to be when the business can't do it anymore. And we don't know what tomorrow holds, much less next week or next month. So no one has a crystal ball on this. But if the business gets to be in a position, or if you get to be in a position where you can't make ends meet and you can't keep the number of people that you have and maintain the benefits that they've enjoyed, and you've tried some of these other measures, reducing hours, potentially reducing compensation, I think that's the point at which you might be in the we might need to make a more permanent break, and then hope that we're in a position on the back end to rehire so that we have continuity of operations, because knock on wood, this isn't going to last forever, and we have to be prepared for when we return to more normal operations. How are we going to ramp up? And so but those are really hard decisions, and obviously they should be very carefully thought out and addressed on a case-by-case basis.
Yeah, and I want to remind everyone that tomorrow at 9:30, the Chamber will host a live roundtable that will provide everyone the opportunity to talk through these specific issues and learn more about what other regional companies are doing, share ideas with each other, and troubleshoot some of this as a larger group of, whether it be HR professionals, COOs, folks in charge of operations, or CEOs. Those of you that are in decision making, places and are trying to figure out how to manage your workforce right now, tomorrow's session would be a great time to chime in. And so, Matt, you and I had talked about this, and it's a pretty niche area, but it does affect some businesses. What about businesses with elderly workers, or those that are known to have compromised immune systems or have been identified as high risk? How should they be handled? And any differences there?
This, I do think, is a difference. So if you set up the general rule that if you're exhibiting symptoms, you're going to be sent home, you're required to be sent home now under the governor's order, and you have someone who's in your workforce who, based on what we've all read, is maybe has a heightened susceptibility to extreme negative consequences from coronavirus. They're either in that age group or age range, or you happen to know that they've been out on leave because they have a recognized immune disorder. Those individuals, if they're not exhibiting symptoms, I think it's highly dangerous to remove them from the workplace unless you're willing to pay them for being out, in part because that decision would be made on the basis of their age or their perceived disability. And there's still the potential for a discrimination claim. You know, removing someone from the workplace, separating them from their ability to earn pay, is an adverse employment action. And I think it would be pretty clear if it was done not on the basis of symptoms, but on the basis of my perception that if you got this, you could be really, really sick. That's textbook discrimination. So if you're in a position to hold them out with pay or provide them benefits, then that probably isn't as much of an issue. You're just saying, out of an abundance of caution to protect you, we're going to not have you work in the workplace, and oh, by the way, we're going to pay you during that time. Many employers, especially increasingly, are not in that particular position. So I would say that's a handle with extreme care scenario.
And so let's switch gears. The majority of the questions coming in have been about the new legislation that's passed. And so if we dive into that a little bit, there's been a lot of movement legislatively. Can you explain what the major changes are?
Sure. The Families First Act, which it's hard to believe it was just signed into law 6 days ago. I feel like I've been living with it for my entire life. It provides two completely new federal paid leave entitlements. There are limited bases, which we're going to talk about, that an employee has to qualify under to receive paid leave under the Expanded Fmla, Expanded Family and Medical Leave Act, and the Paid Sick Leave Act. Those are two completely separate things. And so want to make sure that you keep those separate. They have different reasons that an employee might qualify. But it's really unprecedented. Federal law has never mandated paid leave. It's always left that to the states, which by and large, especially Ohio, leaves that to the individual employer. You could choose theoretically to not offer any sort of paid time off or holiday pay for any of your employees. The marketplace would obviously probably punish that. You might have a little bit of trouble recruiting against companies who do offer those benefits, but that was a possibility in the past. These federal paid mandates are very unique. And so if you want, Shonda, should we start with the family medical leave?
Yeah, let's dig into that one a little bit.
So just as by way of a background, you know, employers who are under 50 employees probably aren't all that accustomed to dealing with Family Medical Leave Act issues, whereas the people who have more than 50 employees, this is the point where they're groaning and furrowing their brows, because family medical leave is a thorny issue for employers to deal with. Traditionally, and I'm going to be speaking of unpaid family medical leave historically, it's job protected leave of up to 12 weeks in duration that can be taken within a 12-month period. That's either calendar year or a rolling year, whether you're looking back or looking forward. And it can be taken in large chunks of time, including 12 weeks all at one time. or small increments in what is called intermittent leave that are measured by units no greater than 1 hour. Not every employee or employer is covered by unpaid FMLA, traditional FMLA. It applies to companies who have more than 50 employees within a 75-mile radius. And that satisfies the definition of a covered employer. In order for an individual employee to have eligibility, the employee has to have worked at least 12 months for that employer, has to have worked 1,250 hours in the preceding 12 months, and then has to need the leave for an FMLA qualifying reason. And there are 3 of those that are the most common. So those are the ones that I'll deal with. There's also military and service member leave, but I'm not going to get into that because that comes up a lot less frequently. But the traditional reasons for leave under the FMLA are the employee has a serious health condition, an employee family member has a serious health condition that the employee is caring for, or the employee's out for the birth or the placement of a child. And so what happens when an employee has one of those issues is they raise the need for the leave to the employer. The employer determines whether the employee is eligible, gives them a notice of rights and determines their eligibility. The employee fills out or has a medical provider fill out a certification that authenticates that the leave is needed, that it qualifies, that it's for a serious health condition of a family member or the individual, or that it's for the birth of a child. And the employee returns that, the employer designates the leave, and the leave starts. And it's capped at 12 weeks. At the end of the leave, the employee must be restored to that employee's job or one that's reasonably equivalent. And there is no retaliation or interference that can be taken by the employer for someone who's exercising this leave. So that's, we could go into depth in any one of those topics. That's obviously not the point here, but that's a basic crash course on the FMLA. The new expanded FMLA is different in 4 main ways. First, it applies to all employers with fewer than 500 employees. There are some possible exemptions that can be issued by the Secretary of Labor that relate to healthcare providers and those with under 50 employees if they can show a hardship in complying. The second quality that's different is that it applies to almost every employee of one of those employers with under 500 employees. It applies to anyone who's been employed for 30 days. So instead of looking back a year and determining has the person worked for 1,250 hours, this is a 30-day eligibility window. That's much shorter. The third factor that's different is there's a very narrow and only one basis for an employee taking this expanded family medical leave, and that is the employee is needed to care for a child, a minor age child, whose school or daycare has been ordered to be closed, and where that employee does not have telework available. And then the fourth component, and this is the biggest component, this is the most radical change, is that this is paid leave. The employee has to provide some notice still. They have to indicate that they need the leave and probably need to indicate that they have a school-age child and are needed to care, make some showing in that regard. The first 10 days of the leave that the employee would take, those are unpaid, but for the remainder of the leave, the remaining 10 weeks, it's paid at 2/3 of the employee's regular compensation. There's a cap on it at $200 a day or $10,000 for the entire period. That is the expansion to family and medical leave.
That's great, Matt. It's a ton to unpack, and I know that businesses are working to unpack all of that. If I drill down a little bit on some of these 4 points, and I'm seeing the questions come in as well. So the first bullet on the slide talks about exceptions potentially for hardship. Where can employees go, and has there been any direction or instruction provided on what constitutes a hardship?
So that's left to be filled out by the Secretary of Labor and rulemaking that's going to happen under the statute. So as of right now, that's not very clearly delineated in the act itself, the expanded FMLA, but we expect there to be guidance that's provided by the Secretary of Labor that will really flesh out, A, how's that process going to work logistically, and B, what might I need to show as an employer to opt out. There's a similar lack of clarity around what healthcare providers are opted out. If the definition of healthcare provider as it usually is in the FMLA is applied, people like dentists and podiatrists would qualify as healthcare providers. That definition historically is, hey, these are people who can fill out a certification that an employee needs to take leave for a serious health condition. Dentists and podiatrists aren't probably expected to be on the front lines of the coronavirus crisis. And so there needs to be some more clarity around what healthcare providers might be exempted from expanded family and medical leave.
And then Matt, you had also made the point that the hours requirement doesn't apply to this, just employment of 30 days. And so whether it's full-time, part-time, if they were scheduled to work just a couple hours a week, they're eligible for these benefits the same as any other employee?
That's exactly right. So the only requirement here is 30 days of employment with a covered employer, which is any employer with under 500 employees.
Okay. And then we've gotten some questions on the childcare component. So to be clear, you're eligible for this expanded FMLA if you have to care for a child as a result of the closure of a school or daycare. But if you have the ability to telework, are you covered?
So no, expressly, if you have the ability to telework, that's where the employer can go, should go. If the employer is looking not to have to pay this particular leave, it's specifically provided that this applies to employees for whom telework is not available.
And then Matt, what about someone's posed a question about, can this leave be offered intermittently? So
I would say probably. That's not entirely clear, but as you might imagine, if the school day lasts from 8 o'clock to 3 o'clock or so, and the individual might have had coverage already lined up from 3 to 5 or 3 to 6 when the normal workday ended, if the leave need is really from 8 to 3, then I could foresee a situation in which intermittent leave would apply. Now, the question is that employee then working from 3 to 5, coming into the office at that point when the need goes away? And if the answer to that is no, then I'd say that the entire day leave was taken for the entire day.
Okay, great. We've gotten a couple of questions from folks that want to know if the sort of request and approval process generally looks the same for this, or if that is lax, and they're asking about, do we still have to require documentation from physicians and schools, I assume, in this case? So do you want to speak to that?
It's still a gray area. So the notice requirements under the statute aren't very well spelled out. That there's probably regulation or rulemaking that's going to come that's going to really specify what an employer can demand as proof, what documentation needs to exist. Obviously, unpaid FMLA, traditional FMLA, is a very form-heavy administration, a number of steps that need to be followed. This emergency expanded FMLA does not have that level of detail just yet.
Okay, great. Let's jump in because we're out of time, but let's try to cover the last big topic, the paid sick leave.
Sure. So this is a completely separate benefit. It has, unlike Expanded Fmla, there are 6 reasons that an individual might qualify for paid sick leave. They're up on your screen. The first 3 reasons really relate to the individual, him or herself. Reasons 4 and 5 relate to the need to care for someone who's either complying with a quarantine order or has self-quarantined on a doctor's or healthcare provider's advice, or a son or daughter whose school has been closed. The 6th reason is sort of a catch-all. I think they don't want to have to go back to the drawing board. They don't know what's coming, and so this allows some flexibility for other pronouncements to be made that are similar in nature that might also be qualifying without having to do new legislation. So 6 different reasons. The amount of leave is different here. So it's 14 days, 80 hours of paid sick leave. It's different for part-time workers. Part-time workers, if they had a fixed schedule, you would they would get 2 weeks worth of their fixed. So say they worked 25 hours a week, those employees would get 50 hours of paid sick leave. The pay that they get depends on the reason that the leave is being taken. So if it's for reasons 1, 2, and 3 that relate to the individual and the individual's illness, it's 100% pay that's capped at $511 a day. If it's for reasons 4, 5, or at this point 6, it's paid at 2/3 of the employee's regular compensation, and the cap there is $200 a day. Again, there's a healthcare provider exclusion. In this instance, they specifically say that the definition of healthcare provider that the FMLA uses will apply. So I suppose that answers the question, at least for paid sick leave, that there's a very broad definition of healthcare provider who can be exempted from the Paid Sick Leave Act.
Okay, Matt, we have 2 questions that I know people really want to get answers to.
Before those, I want to make sure that there's going to be a model notice. So those of you who are familiar with posting notices in the break room, there's going to be a model notice issued in the next week to 2 weeks that you will need to post that advises an employee of his or her rights under the Expanded Fmla and the Paid Sick Leave Act. So stay tuned for that, because that's something that non-compliance could have consequences.
So with these changes, with the new paid leave requirements, where do employers get the money to do this?
So the initial way that they contemplated doing this is tax credits against an employer's FICA withholdings that they make on the employee's behalf, so Social Security and Medicare. The thought was that the employers would pay, and then on the back end, they could recover these costs, these outlays, in the form of tax credits. The Department of Labor just over the weekend with the IRS agreed that the employer need not make the federal FICA withholdings. It can use that money or earmark that money toward paying benefits under the Expanded Fmla or the Paid Sick Leave Act. And so if an employer is wondering where's that money going to come from, their quarterly expenditure for FICA can be withheld from being deposited with the federal government and actually paid to the individual employees who are receiving leave under these legislative acts. So that's one source. Obviously, there are a whole host of small business association loan offerings that are available that could float a company on very low interest, very favorable repayment terms that could allow someone to be able to meet this obligation, or it's coming from operations or the employer's assets. Otherwise, if an employer can't make these payments, there's not enough in the withholdings, or almost the entire workforce qualifies, even though the restrictions are pretty limited, almost the entire workforce qualifies for this type of leave. that's going to be a financial situation that may cause a layoff or more drastic action.
And so, Matt, what are some rays of hope here? If you can leave us on an optimistic note, what are some things that you would encourage us all to focus on right now?
Sure. And I mean, reading the news even before all this was depressing enough, but these days it's heartbreaking to read the human toll of this and see what it's doing to companies and real lives. And so I don't want to seem, ghastly to think about what the effect might be on businesses after we're done with this. But I do see some possible rays of hope down the road that will maybe come from having experienced this crisis. The first is that companies that are really leaning into telework options might, figure out the answer to that question. What meeting could have been an email? Things are being streamlined and done much more efficiently. If telework is available, that flexibility may be good for businesses in the long term. The second piece of advice or possible solace I would have is when we work our jobs day to day, we don't really have time to map what we do, to figure out whether our processes are the most efficient, to figure out what actually is required for the business to continue and what isn't. And in this period of making these very difficult decisions might make us more informed about what it actually takes to do the job in a way that makes us kind of leaner and meaner on the back end. And then finally, I think there's a benefit in pulling apart the way we've all been forced to. We have to quarantine or socially distance, and we are communicating remotely at all times. You're really the first person that I've seen in, I don't even know how long. I haven't left my house. This is the first time I've tied a tie in weeks. And so I think that our absence from one another will make the point at which we can all come back together that much more meaningful. We'll really appreciate what we're able to have when we can come together in a workplace as coworkers and do a job to try to solve a problem for someone or to make a better life for ourselves and others. So I think those are some of the benefits that may be realized from this, but obviously it's a very hard situation.
Absolutely. I think we thank you, Matt. We thank you for those notes of optimism and ending it on that positive note, as positive it can be. I think we all understand that we are in this together and figuring it out together. I want to thank you specifically today and for fielding the questions, a lot of which we didn't discuss ahead of time. So thank you for being willing to do that and directly responding to the group's questions as they came in. For everyone that's joining the call, thank you. Thank you for submitting the questions. We hope that you found this time to be really useful. Again, tomorrow morning at 9:30, we will have more live discussion. While Matt won't be there to provide his expertise, we will be relying on each other and as a community to talk about and share what different organizations are doing. It could be helpful for many of you to learn how others are managing through this. And then also on Thursday, the Chamber is hosting Dr. Chantel Thomas to discuss mental health issues and solutions, strategies for leaders and individuals to manage stress and reduce anxiety. I know we all could use that right now. And I just want to say that our entire team at the Chamber is dedicated to keeping our business community united through this and strong as we recover. So please let us know how we can be of service to you. Stay safe in your homes unless it's unavoidable, and respect social distancing at all times. Thank you all so much.